Ladies and gentlemen, fasten your seatbelts because we're about to embark on a legal roller coaster that's more jaw-dropping than a magic trick at a circus. We're diving into the heart of the Purdue Pharma saga, a tale of epic proportions that involves billions of dollars, a family dynasty, and a nationwide crisis that's rocked the very core of our society. Get ready to be thrilled, amazed, and utterly engrossed in this story of legal high stakes. Imagine a world where the wealthy Sackler family, like chess masters plotting their next move, were offered a deal that would shield them from a barrage of lawsuits in exchange for a mountain of cash for the victims of the opioid epidemic. It's like watching a high-stakes poker game where the chips are people's lives and the players are caught in a high-octane legal duel. Hold on to your gavels because the Supreme Court, like a sage old wizard, announced that it's pressing the pause button on this mega deal. Yes, you heard that right. The court, like a referee in the biggest match of the century, blew the whistle and called for a timeout. What's at stake? Well, it's nothing short of a bankruptcy deal for Purdue Pharma, the mastermind behind the prescription painkiller Oxycontin, one of the most notorious names in the opioid saga. But here's where it gets even more thrilling. This deal, like a puzzle piece in a massive jigsaw, touches on one of the most seismic public health crises the country has ever seen. It's like watching a blockbuster movie unfold, where the stakes aren't just money, their lives, their families torn apart. They're the essence of a nation at a crossroads. And guess what, folks? The Supreme Court isn't just pausing this party, they're diving headfirst into the fray. Think of them as the fearless heroes, donning their legal capes and stepping onto the battlefield. The court isn't just watching from the sidelines, they're putting the case on their docket, scheduling an epic showdown in December where words will fly like arrows and arguments will clash like titans. But what's the big picture here? Well, hold on to your popcorn because this decision isn't just about Purdue Pharma, it's about the entire galaxy of cases that use bankruptcy as a battleground for mass injuries. It's like watching a domino effect where one decision ripples through the legal cosmos, changing the game for everyone involved. Question number 1, why did the Supreme Court decide to weigh in? Now, you might be wondering, why on earth would the Supreme Court get involved in a bankruptcy court dispute? Oh, strap in, my friends, because we're about to uncover the juicy details that will leave you at the edge of your seat, craving for more. Picture this. A mass injury case swirling in controversy, a settlement agreement hanging in the balance, and a cast of characters that would make even Shakespeare raise an eyebrow. The Supreme Court doesn't just waltz into any old courtroom brawl, but when they do, you better believe it's for a showdown of epic proportions. But wait, there's more. Brace yourself for the jaw-dropping twist that few saw coming. You see, these courtroom duels are like high-stakes poker games, and all the players are dealing with their cards under the table. That's why it's rare to witness the Supreme Court diving into the fray. But in this case, it's the equivalent of legal fireworks lighting up the sky. Now, imagine this. The United States Trustee Program, a sly watchdog within the Justice Department, steps up to the plate. They're not just here to watch the show, they're here to flip the script. They march into the Supreme Court, waving the flag of justice, and demand a review of the deal. It's like watching a chess master make a daring move, setting the stage for an electrifying match of legal wits. Hold on to your gavels, because that's not all. There's a potent cocktail of elements swirling around this case that makes it impossible to ignore. Enter the opioid crisis, a nationwide issue that has us all at the edge of our seats. This isn't just a dispute. It's a battle against a raging storm that has swept across the nation, leaving a trail of destruction in its wake. The Supreme Court knows that this is no ordinary skirmish. It's a fight for the very heart of the nation. But wait, there's a twist that even the most astute legal minds couldn't have predicted. We're talking about those elusive third parties, the shadowy figures lurking in the background, manipulating the strings like puppet masters. In this gripping saga, it's none other than the Sacklers, the puppeteers behind the curtain who held the reins of the company. They're pulling the ultimate disappearing act, shielding themselves from the storm while the world watches in disbelief. And that's not all. Brace yourselves because the lower courts are divided. It's like watching a tug of war where the rope is the law itself, and the judges are the contenders locked in a fierce battle of ideologies. Will these agreements allowing third parties to dance away from the spotlight continue to divide the courts? Will the Supreme Court swoop in to settle this legal turbulence once and for all? The suspense is killing us! Question number 2. What are the broader implications for mass injury cases? Imagine a world where businesses and plaintiffs are dancing on a high wire, trying to find the perfect balance between justice and resolution. Enter the Purdue Pharma deal, a potential game changer that's lighting up the legal sky like fireworks on the 4th of July. If this deal gets the green light, it's like handing out a roadmap to other hopefuls in the same game. Mass injury cases, you say? Well, now they have a compass pointing straight to the bankruptcy courts for a taste of that tantalizing resolution. But wait, there's a twist in this tale that could rival the best mystery novels. Picture a courtroom packed with legal legends, and in one corner, the Supreme Court raises an eyebrow and casts a discerning eye over the stage. The question of the hour: should we shut down the dazzling mechanism called non-consensual third-party releases? It's like pulling the rug from under the Sackler family, the puppeteers behind the scenes, and suddenly their shield against the storm of civil lawsuits is in jeopardy. Hold on to your gavels, because this isn't just about the Purdue Pharma deal. It's about setting off a chain reaction that could send shockwaves through the world of litigation. Think of it as legal dominoes, each one affecting the next in a mesmerizing cascade. The entire Purdue Pharma bankruptcy settlement deal, years in the making, teeters on a precipice. If the Supreme Court slams the door on those third-party releases, it's like watching the first domino fall, triggering a symphony of legal chaos that echoes far and wide. Oh, but that's not all, my friends. Get ready for an epic showdown where battles are fought not with swords, but with lawsuits and arguments. As the Purdue case unfolds, legal eagles are keeping their eyes glued to other spectacles like the Revlon bankruptcy. It's like the legal Olympics, where the outcomes of one case have the potential to reshape the playing field for everyone else. Now, here's the million-dollar question. What happens if the Supreme Court gives a resounding no to those third-party releases? Hold on to your legal dictionaries, because it's like throwing a curveball that could shake the very foundation of these settlement deals. The uncertainty, the suspense. It's like watching a suspense thriller where the fate of corporations and plaintiffs hang in the balance. Question number 3. How is the Supreme Court likely to view this case? Now, my dear audience, picture this. A courtroom where the air crackles with anticipation. A canvas where the landscape shifts with every uttered word. As we gaze upon the Supreme Court's canvas, the question on everyone's lips is, how will the mighty justices perceive this case? Brace yourselves for the ultimate showdown between business interests and the power of skepticism. On one hand, we have the conservative majority, a powerhouse that has been known to favor the business world. Think of them as the knights on the legal chessboard, galloping boldly into the fray with banners held high. However, in this labyrinth of justice, even the knights have their quirks. Enter Chief Justice John G. Roberts Jr. and Justice Clarence Thomas, the cautious tacticians who cast wary eyes on aggressive litigation tactics. It's like watching a Shakespearean drama unfold, where even the most steadfast allies might harbor doubts. But hold on to your gavels, because we're not in predictable territory anymore. The Supreme Court is like a mystical forest where paths are shrouded in mist, and even the most skilled trackers can't predict the way. Enter the liberal justices, the defenders of principles that intertwine with the winds of change. As they step onto the canvas, their motivations are as enigmatic as the Sphinx's riddles. Court watchers, those vigilant observers of the legal cosmos, are left scratching their heads. Could this be the ultimate procedural case, a puzzle that brings forth a split vote that defies the boundaries of political or ideological allegiance? It's like watching a tightrope walker tread across a wire so thin that it might snap at any moment. The suspense is palpable, the stakes immeasurable. Now, imagine this, my friends. A courtroom that pulsates with energy, where words hold the power to shape destinies. The conservative majority weighs business interests against the backdrop of skepticism, while the liberal justices navigate the labyrinth of ideals. It's a battle that transcends political lines, a ballet of legal minds that leaves us all in awe. Question number 4. Why is only the Justice Department objecting to the Purdue plan? Picture this. A courtroom that crackles with tension where thousands of plaintiffs, from states to local governments, tribes to individuals, have waited patiently for the storm to pass and settlement funds to arrive. But time waits for no one, and as the litigation clock ticks, the value of those funds begins to wane. It's like watching a race against time where every second lost chips away at the relief these plaintiffs so desperately need. Hold on to your gavels, because here's where the plot thickens. The Sacklers, the elusive puppeteers behind the scenes, start inching up their offers like a sly magician, revealing just enough to keep the audience intrigued. Even the most stubborn states that once held their ground are swept up in the whirlwind, relenting as the Sacklers dangle their financial carrot. But wait, my friends, the battleground isn't just about dollars and cents. It's a war of principles, a clash that's reminiscent of a medieval joust where ideals jostle for dominance. As the U.S. Court of Appeals for the Second Circuit steps onto the scene, the stakes have soared to unimaginable heights. With $6 billion from the Sacklers on the table, it seems like the last major party holding out is the U.S. Trustee Program. Enter the U.S. Trustee Program, the valiant defender of principles, storming onto the battlefield with an objection that could reshape the destiny of the deal. They're crying foul, declaring that the Sacklers could waltz away with all the perks of bankruptcy, like a cloak of protection against lawsuits, while sidestepping the costs of scrutiny. It's like watching a courtroom drama where the spotlight shines on the dark corners of legal tactics. Hold on to your legal dictionaries, because it's about to get even more complex. Imagine people who, against all odds, still want to chase the Sacklers into civil court for their actions. If this deal gets the green light, they'll be locked out, like the doors slamming shut in the face of justice. The U.S. trustee roars that this is a breach of constitutional due process, a violation that would echo through the legal ages. But my dear viewers, there's a dilemma. As the Purdue litigation rages on, the clock ticks louder for those in the throes of the opioid crisis. Tribes, states, local governments, and individuals caught in the storm of addiction have urgent costs to address. The battle of principles and the pursuit of justice have reached a crossroads, where urgency clashes with ideals in a symphony of legal intrigue. Question number 5. What does the plan offer states, local governments, and tribes? Imagine a world where dollars fly like confetti at a rock star's concert, where settlements stretch like bridges across chasms of litigation. Enter Purdue Pharma, bearing gifts of $1.2 billion, poised to make it rain as soon as they emerge from bankruptcy. It's like watching a high-stakes poker game where every move is a calculated risk and the fate of thousands hangs in the balance. But wait, there's more! The Sacklers, those elusive enigmas, step onto the stage, promising a staggering $6 billion over the course of 18 heart-pounding years. The first 9 years alone promise an avalanche of almost $4.5 billion. It's like watching a financial tightrope act where the balance between wealth and responsibility teeters on a knife's edge. Hold on to your gavels, because this isn't just about dollars and cents, it's about justice and redemption. Enter the tribal plaintiffs, those valiant defenders of Native American tribes who stand united against the storm. A trust worth approximately $161 million stands like a fortress, ready to provide a lifeline to all 574 federally recognized tribes. It's like watching a grand alliance form to claim their rightful piece of the puzzle. But the tale doesn't end there, my friends. Picture a courtroom where states and local governments huddle together like comrades in arms, forging formulas to distribute the Purdue treasure trove. It's like watching a band of pirates divvy up their loot, each one claiming their share with a mix of caution and excitement. Now here's the twist that'll make your legal senses tingle. There's a rule book, a guide that all must follow. This treasure must be spent with care, channeled towards the common goal of conquering the opioid crisis. Addiction treatment, prevention, and initiatives to ease the storm. These are the real treasures that the Purdue deal is intended to unlock. But don't be fooled, dear viewers, this isn't just about paperwork and numbers. It's about lives changed and battles won. Imagine the transformation that $1.2 billion can bring to those struggling with addiction, the power of $6 billion to build bridges toward healing. It's like watching a phoenix rise from the ashes, reborn through the flames of redemption. So hold on to your seats, because the climax of this legal drama is upon us. As Purdue Pharma emerges from the shadows of bankruptcy, as dollars flow like rivers, and as tribes, states, and local governments embark on a journey towards a brighter future, remember that what we're witnessing is a fight for justice, a quest for redemption that could change lives for generations to come. Stay tuned, because the grand finale promises to be an unforgettable crescendo of justice, hope, and the triumph of the human spirit. Question number 6. What about individual victims? Imagine a world where heroes rise from the shadows, where a trust worth $700 million to $750 million stands like a fortress, ready to embrace the victims and families who bore the brunt of Oxycontin's deadly embrace. It's like watching a superhero gathering, where each story is a badge of honor, each struggle a testament to the human spirit's resilience. But here's the twist that'll tug at your heartstrings. A staggering 138,000 plaintiffs filed their claims, each one a warrior in the battle against addiction. Think of them as the Avengers, united in their quest for justice and retribution. And now, with the Purdue plan unfolding, payments are on the horizon, ranging from $3,500 to $48,000. It's like watching a reward ceremony where every hero gets their moment in the spotlight. Hold on to your capes because there's more! Picture 6,550 children, innocent bystanders caught in the crossfire, experiencing withdrawal symptoms from drug exposure in the womb. But fear not, for they have their guardians, the protectors who stood firm in the face of adversity. With the Purdue plan's blessing, each guardian is set to receive around $7,000. It's like watching a heartwarming embrace, where the wounded find solace in the arms of justice. But here's the kicker, my friends. These payouts might seem small in the grand scheme of things, but they're monumental in the journey to healing. Think of them as tokens of acknowledgement, as a promise that their suffering won't go unnoticed. And here's the icing on the cake. The Purdue plan is a trailblazer, one of the rare opioid settlements that carves out a piece of the pie for the individual heroes. Now imagine a world where those who suffered finally find their voices heard, their pain acknowledged, and their struggles validated. It's like watching a phoenix rise from the ashes as individual victims turn into symbols of strength. With payments ranging from thousands to tens of thousands, it's a nod to their fight, a salute to their bravery. Question number 7. If the plan is approved, what happens to Purdue? Imagine a world where a company that once roared onto the scene, introducing Oxycontin with all the flair of a rock star's entrance, is now facing its final curtain call. Purdue Pharma, the once mighty titan, would vanish into thin air like a magician's vanishing act. But don't worry, dear viewers, this isn't the end. It's the beginning of a rebirth. Hold on to your seats because here's where the plot thickens. Purdue's assets, like treasures from a fallen kingdom, would find new life in a company called Knoa Pharma. Picture it, a phoenix emerging from the ashes, ready to reshape the world of medicine. But here's the twist that'll make your eyebrows shoot up. Knoa Pharma won't be your typical company chasing profits. Oh no, it's like a knight in shining armor, ready to manufacture addiction treatment and opioid reversal medicines at no profit. It's like watching Robin Hood, but instead of stealing from the rich to give to the poor, it's taking from addiction to give back life and hope. But wait, there's more. Knoa isn't just a selfless hero. It's a hybrid powerhouse that's here to revolutionize the game. It's like watching a double agent in a thrilling espionage movie. While it's manufacturing addiction treatment and life-saving medicines, it's also keeping the legacy of Oxycontin alive. Yes, you heard that right. Oxycontin and other opioids will continue to be part of the portfolio, but the profits won't line pockets or build empires. They'll flow like a river into the settlement funds, like a contribution to the healing of a nation. Now imagine this, my friends. A world where Purdue Pharma, once the puppeteer, is now a puppet itself, dancing to the rhythm of an independent monitor's baton. It's like watching a mighty general put under the watchful eye of a vigilant commander. The Sacklers, those elusive figures that once pulled the strings, are now absent from the board, like the finale of a Shakespearean tragedy. But hold on to your hats, because this isn't just about business transactions. It's about rewriting history. It's about a company shedding its past and rising from the ashes, reinventing itself as a beacon of hope. It's about a legacy being reshaped, a story that's bigger than profits and assets. So fasten your seatbelts, dear viewers, and get ready for the ultimate transformation. As Purdue Pharma's final act unfolds, as Knoa Pharma steps onto the stage, remember that we're witnessing a narrative that transcends business deals. Will Knoa Pharma be the hero that changes the tide of addiction, that ushers in a new era of compassion? Will Purdue's vanishing act give rise to a legacy that's rooted in healing and transformation? Stay tuned, because the story is far from over, and the chapters yet to be written promise to be nothing short of extraordinary. It's been a legal roller coaster, my fellow seekers, and remember to smash that like button, subscribe if you haven't already, and hit that notification bell so you never miss a thrilling legal revelation. Until next time, stay curious, stay engaged, and let's conquer the world of law together. Dear viewers, that was only one question answered. To get more answers to questions regarding this Supreme Court case about Purdue Pharma, get back to my channel and check my uploaded videos where you will get more information regarding this case. And as you are already into my channel, I am sure that you will press that nasty thumbs up for me and subscribe to my cute mini channel so that it grows more. Thank you in advance. Bye, my cranky viewers.